Hi, Nader. How are you?
I'm great. Thanks for having me.
Well, I'm very happy to see you, and I want to start by congratulating you on the award that you recently received, the Catzman Award for Professionalism and Civility. The
Thank you.
big award. Very, very happy for that, and I know many of our colleagues are happy for this recognition. It's very well deserved. And I'm not going to ask you the stupid question of how do you feel about getting an award because obviously you're happy, but I'm going to ask you, Nader, what the meaning of that award is, and in the sense of now what do you feel
Yeah,
comes with the responsibility of getting
yeah.
recognition and an award?
No, that's a very fair question, and thank you for your kind words. Look, we don't do this. I don't do what I do. You don't do what you do for the accolades or the awards. We do what we
Yeah.
do to help people, and because we believe deep down, we believe that our system can provide justice. So that's why we do what we do. But I'm not going to lie and say it doesn't make me feel good that the hard work and sweat and tears is being recognized, and I'm very grateful to the selection committee and the Catzman family for selecting me this year. Look, I think part of what the award is about is it's about mentorship, it's about professionalism, and I think in my head, I just have to redouble my efforts to try to do what I've been doing and really pay it forward. I've been recognized for the mentorship and the teaching, and that's something I want to continue doing, perhaps to an even greater extent, because there are so many good young lawyers in the criminal defense bar coming up, and some of them have been, I think, penalized by the fact that we've been living through this COVID pandemic and we haven't had in-person court. And some people graduated from law school and entered the profession when we were still in lockdown measures. So there's some really good, hardworking, dedicated folks who are trying to catch up, and I think that it behooves us all. Those who've been at it a little bit longer to try to help them get to the point where they can really sink their teeth into this profession and really start becoming, feeling like they're valued members and contributing members of the bar.
Yeah. Well, I know you mentioned that you mentor, you teach, but I'm also going to add one thing you forgot to mention is that you also write books because there is like a book on charters, charter applications, I think, with Iman that you've published. So you're also an author. So that's also a contribution to the profession.
I mean, we all have to try to write a little bit.
Yeah.
I think it's part of what we do. And when you litigate cases, you have ideas and for articles and sometimes books. And yeah, it's something I try to do. It's time consuming, but it's fulfilling.
But okay, so speaking of time consuming, because you do have a very busy practice and you do a lot of, we see your name a lot in uh, the appellate level, Court of Appeal, Supreme Court cases, but you're also a trial lawyer. So maybe if you can just tell us a little bit about what you do on both levels and how do you balance this very busy practice? It's hard to do both.
Yeah, it is, but I think it's fulfilling. It keeps things interesting. At any given year, I'm about, either 60-40 trials appeals or 40-60 trials appeals, sometimes 50-50. I really do like the balance because while you know there are transferable skills, it's really a very much of a different process, and there are different skills that we bring to bear, whether it's at trial or on an appeal. Appeals sometimes are more intellectually stimulating in the way that you can sink your teeth into a novel or interesting legal issue and you can get creative with the law. Whereas trials are fulfilling on a different level, right? Because we get to not just make arguments about the law, but we get to craft the record through our examinations and cross examinations. So as an advocate, you really feel like you can make a difference in the process and really further your client's cause. Whereas on an appeal, as interesting as they may be, you may be somewhat hamstrung about by the record that's been created for you at trial. Now, both have a lot of fun involved in doing them, and then both have their various challenges. And I think the way to keep life interesting is do a little bit of both.
Well, but you did mention the creativity on the appellate level. So I want to talk a little bit though about because you did do something very interesting, the case of Sharma. I know that ultimately didn't go the way you wanted, but it was a very interesting argument because you actually used Section 15 of the Charter, which is not something that we usually use in criminal law. Like we're usually limited to Section 7 to 14. So Section 15 is really outside of our practice. So that was a very creative and interesting thing that you did. And that's why a lot of people were very interested in that
Yeah.
case. So, I mean, if you can tell us though about this, because I mean, I admire the fact that you did that. It's a very interesting argument that you made in
Yeah.
Sharma.
No, that's thanks for bringing up that case. I was in a really good jovial mood when this interview began, and then you reminded me
Oh,
about the Supreme Court of Canada's decision in Sharma, which I'm still quite sour about the 5-4 decision. No, look, that was an important case. It was a case that needed to be brought.
yeah.
Going back to law school for me, which is now a number of years, I had come away with the impression that Section 15 of the Charter had become a dead letter when it came to the criminal law. You could make equality-based arguments in the criminal law using Section 7, sometimes Section 2A, but Section 15 arguments seem to go nowhere. And that makes no sense to me, given that
Yeah.
Section 15 is the equality guarantee in the Canadian Charter of Rights and Freedoms. And we know that our criminal justice system is replete with inequalities.
Mm-hmm.
And so it just as a matter of first principles, it makes no sense to me at all that Section 15 is underutilized in the criminal context. And the reason it's been underutilized is because the Section 15 arguments had time after time been shot down. So I'm not in any way being critical of the bar. Everyone was making Section 15 arguments, and the courts just weren't having it. And so I think after some time, people just stopped making the Section 15 arguments and
Yeah.
have relied then exclusively on Section 7. Sharma was a case, and credit goes to the folks, especially and including Aboriginal Legal Services and Jonathan Rudin and his team at the trial level for helping to build a thorough record, including robust expert evidence that allowed them at the trial level and allowed us at the appeal level to marshal a Section 15 based argument that the Court of Appeal was found favor in, and ultimately the Supreme Court of Canada rejected that argument in a 5-4 decision. I just hope, though, that despite that loss, that people continue to try to get creative in using Section 15 in the criminal law context. There
Well,
really ought to be a place for it.
Well, Section 15 and the other sections as well, right? Like the charter is not just 7 to 14, but that's why I think what you did, Nader, is actually very interesting and important because you made us realize that there are more sections that we could apply in the criminal context, but we don't. We just always limit ourselves to 7 to 14, but there are other, like 15, that can also apply. So I know you're not very happy ultimately with what happened, but I think you did something very important because I think it's very interesting for young lawyers to think about using these other sections because they do apply. Why wouldn't they apply? I mean, there's no reason for them, right, not to apply in the criminal context.
I think that's right. And I think we have a lot of really good judges out there who are receptive to novel arguments. So if you back up your arguments with a proper record and properly sourced legal argument, they will go there. They need the lawyers to bring it to them, but they are willing to go there.
But on this point, because this is something that, it's not easy. Like sometimes maybe some people will tell you, no, like, why are you doing this? Try something else or just forget about it. But you went on with this argument and you brought that argument, which was new, not a lot of cases in criminal use Section 15. But I mean, if I'm thinking of lawyers who are watching, because a lot of lawyers admire your work and they look up to you, and if they want to say like, oh well, I want to do what Nader did, what is your advice to those lawyers who want to try something new but they're maybe afraid, they don't have the confidence, they're getting backlash from people? What would you say?
Well, look, I think the first thing to bear in mind is if you think it's a good idea, it very likely is a good idea. Just because it's novel and hasn't been tried before, that's not a reason to disregard it. And if you're unsure, talk to folks. Talk to folks within your chambers or your firm, or call me up or call you up, Maya. People
Mm.
who have tried to make novel arguments before. I think one thing that younger criminal defense counsel need to remember is that we have an extremely welcoming, approachable bar. And in this area of law, people are kindred spirits. 99% of the criminal lawyers I know are in this profession because they care about promoting justice and advancing justice. And I think when they hear of a young lawyer with an interesting novel idea, reflexively they will want to help. So I think people should feel eager to reach out to others and share their ideas, and I think they'll be surprised at the uptake they get.
Yes. And I'm guessing that when you got that idea to argue the Section 15, I mean, you probably, in your gut instinct, you feel like there's something exciting. You know that this is going
Of
to
course.
be an interesting argument, right? Like that's sometimes what tells you that you have something going on here.
Yeah, and I mean, look, this was Sharma was very much a team effort, and there were a lot of
Mhm.
people who've been talking about these issues for a while. And then, as I mentioned, Jonathan Rudin and his team at Aboriginal Legal Services, my law partner Stephen Aylward, we were all talking it through. It all seemed like something that was the thing about the law is that at least our legal system is you have to have this belief that it is going to arc towards justice. There are going to be these blips over time where it feels like the law is moving backwards, but you have to believe to function within this system, you have to believe that there is this teleological progression. And yes, for a long time, Section 15 had not been moving forward in the criminal law sphere, but it just didn't make sense, just as a matter of common sense, as a matter of morality, and as a matter of the logic of the rest of the charter. And so I think we felt that regardless of what the courts had held up until then, it was still the right argument. And even if we were going to lose, it was an argument that needed to be made.
And it has to be made at some point for it then to progress and become acceptable, right? Like someone has to start using it. It might fail at the beginning, but if it becomes more common and people get used to using it, then it will become like section 7 to 15 as opposed to 7 to 14.
Well, I think that's right. I think that's right. And I mean, like, that's the whole reason why judges at the appellate level, they write dissents, you know?
Mm-hmm.
It's not just to sound off and tell their colleagues how wrong they are. It's to plant the seeds of, there are reasonable jurists can disagree about this issue, and then maybe future lawyers, future judges, future law students will take up some of these ideas and will revisit some of these ideas because who's to say we aren't going to be wrong today and right tomorrow?
Right, exactly. But speaking of Section 15 and equality rights, I want to talk about a specific group, and that's the Muslim community, because I know that you do a lot of work representing Muslims or involved in representing the Muslim community. So I would like you, Nader, to talk a bit about that, and also about the image that Muslims have in the legal profession. And do you feel like it's getting better or is it getting worse? What is your take on that?
Yeah, I mean, look, I've always found our legal profession to be a very welcoming space. And as someone who is Muslim, and I've always identified as Muslim, um, coming up through the legal profession, I've always found it to be a welcoming space. Having said that, Canadian society at large, look, there are a lot of issues that the Muslim community faces that they shouldn't have to face, and that they are facing only because they are Muslim. It still appears to be acceptable within the bounds of mainstream commentary to put out completely bigoted statements and ideas vis-a-vis Muslims in the editorial pages of the National Post and Toronto Sun. That unfortunately, it's not considered beyond the pale yet. It would be characterized as a conservative opinion, but it won't be characterized as a bigoted opinion, no matter, even if it is actually quite bigoted toward Muslims and towards Islam. And this is, I think, this is a reality of the post 9/11 world in which we live, in which, for example, the Trump travel ban is considered as, there are some on the left who will deride it as abject racism, and others forget about it after a while. And we live in a society where Bill 21 is not universally derided. This is the Quebec anti-religious paraphernalia, but what it really is an anti-hijab law. That
and
law.
In France, I mean, even in France, outside of Canada,
France, yeah.
going on.
Yeah, I mean, look, it's in France. It's been going on for a long time. In Quebec, there are those who are brave enough to stand up and say this is just blatant bigotry, and then there are others who are willing to say, well, look, this is about Quebec values and secularism, etc. And they're not willing to use the racism word or the bigotry term to call out what it blatantly is. And so this is the backdrop, of the society in which we live. And I mean, I think part of our obligation as lawyers within the profession, but also Muslims, is to call out these blatant injustices and call out the hypocrisy, and call out politicians for not calling something that is clearly bigoted and racist, and because they're overly concerned about the Quebec vote. And so, look, this is something that I think a lot about as a Muslim lawyer, and I think that we have this moral obligation where we've given the privilege of practicing law. We have the rights language toolkit at our disposal. We know it. We speak that language as Canadian trained lawyers. So I think we have that, not just the opportunity, but the obligation to advocate, not just for our own community, but for all minority communities.
Yeah, because I mean, one thing that we notice in the criminal law is that we have legal principles that apply specifically to Aboriginal communities, or now a little bit more recognizing the Black community. But the Muslim community is also suffering a lot when it comes to crime. Like it's if you look at the names on the docket, it's always a Muslim name. It's like it's very often that you're going to find a Muslim name, and we don't see a lot of, like, the cases don't seem to talk too much about that as much as they do about other minorities. So I mean, there is some kind of also unfairness, I think, within the minority groups and the way they're being treated. I mean, don't you think?
I think that's fair. One might say that there are criminal laws specifically applicable to the Muslim community if we see how they're applied. I mean, Part 2.1 of the criminal code, the anti-terrorism provisions seem to be disproportionately used when it comes to Muslim accused. I mean, those provisions, as you know, are so broadly written. Anytime you commit an offense for a political or ideological purpose, you could lay the terrorism charge. But it hasn't been until very, very recently that we start using, that we see the state start using the terrorism provisions for anyone other than Muslim accused persons. And it's very, very recent, and it's been after literally decades of folks pointing out the hypocrisy here, that these provisions tend to only be used when the accused is a South Asian, Arab, Somali person with a Muslim sounding name.
Yeah. But do you see that there is an improvement in the way in the treatment that they're getting in the law, or are you pessimistic?
I mean, I'm pessimistic about those terrorism provisions,
Okay.
period, right? So the fact that now white people who are non-Muslim are being charged under the terrorism provisions, that doesn't give me any comfort really, because I think those provisions are overbroad in and of themselves. And the fact that they're now being applied more broadly, on one hand, could be considered a victory and on some level, because they're not just being used vis-a-vis Muslim accused, but I mean, I think that masks the larger discussion about whether or not we really need these provisions in the criminal code. It was already, it's already a serious offense to kill someone, and whether or not charging them with terrorism adds anything, I'm yet to be convinced that it does. So, I mean, whether you want to call that improvement or not, I don't really know. I don't know about that. But to your larger point, I do think it's a source of concern that if you were to go on the daily courts list for Toronto or Ottawa or Brampton for tomorrow, and you look at that docket, you're going to see name after name after name that's Muslim, Muslim sounding at least, right?
Mm-hmm.
And it's not something that we seem to be talking about very much.
Yeah. Well, I mean, I like to be optimistic. I hope that things are getting better, even though they may not look like they are right now. But Nader, I wanted just one last topic that I wanted to cover. We did chat a little bit about that before we started recording the interview, and it's the problem that we're seeing right now with a lot of lawyers leaving the profession. I mean, it's becoming really depressing when you lose your friends, they go to the Crown's office, or they just leave the practice of criminal law altogether. I mean, what is the solution? What do you think should happen or could help in maintaining people in the bar?
Yeah, I mean, look, this is really a sad state of affairs. Really good people are leaving criminal defense, not because they don't find it fulfilling. I mean, they love the practice of criminal defense, but people have to be able to put food on the table for their families too. And the economics of criminal defense practice, particularly if you are taking legal aid certificates, it's really quite daunting. I mean, the legal aid needs to be updated in a very serious way. I mean, the notion that legal aid will pay 2 hours or $303, I think that's the block fee tariff for a bail hearing. Bail hearings, as you know, you might spend anywhere from a few hours to 20, 30 hours preparing for a bail hearing. Or this notion that you can bring one charter application in the case and you're going to get paid for 2 hours. I mean, I don't think I've ever argued a charter application where I've spent less than 50 or 100 hours on a charter application, and legal aid says it's worth 2 hours, and you got to pick just one. I mean, it's just ludicrous. I mean, legal aid is only slightly subsidized pro bono, which means we can afford to do only a little bit if we're going to try to cover our overhead, and that's daunting. It wasn't always like that. I talked to folks who came out in the 70s and 80s, and legal aid work was never lucrative, but it was a way of sustaining a practice. But nowadays, it's prohibitively expensive to subsidize legal aid work with the rest of your practice. And I think when legal aid is like this, and we have this state of affairs, you're going to drive people out of the profession. And those who are going to be most acutely affected are first generation lawyers and women. And we're seeing that. How many really, really smart women who practice criminal defense, who are great lawyers, who are really passionate, how many do we see going to the Crown's office? And look, everyone has their reasons for going to the Crown's office, but I would hate to think it's because it's become cost prohibitive to practice criminal defense.
So what is the solution though, other than legal aid? I mean, we have to though recognize that legal aid has recently announced that there
Yeah,
will be some increase. So I mean, hopefully though.
sure, right. So now people taking legal aid certificates go from being colossally underfunded to just woefully underfunded. So,
Yeah.
but fine, yeah, there has been this recent improvement. I think we have to keep agitating. I know no one wants to see another legal aid strike,
Mhm.
um, but I think the bar needs to keep advocating. I think the governments need to step up. I mean, the only true solution to the legal aid problem is for governments to properly fund it. And I think the Law Society should be making its position on this very clear as well. And the leaders of the profession, not just within the criminal defense bar, but within the bar as a whole, needs to recognize that this is not just a criminal defense problem. If you don't have a vibrant, functioning, diverse criminal defense bar, you don't have a just legal system. And I think the rest of the bar needs to advocate for this, not just us.
What do you think criminal defense lawyers can do to let the public recognize that their work is important? Because I think that the another problem is that a lot of people don't really value our work. They really look at us are like the people who defend criminals. So
Right.
what can we do to give a different image about our work and our profession?
Yeah, I mean, look, that's a great question, and I think that work needs to be done at a macro level and a granular level, in
Mhm.
terms of what civil liberties organizations and the CLA can do, and what we can do when speaking with friends, family, and our own communities. I mean, I think there does have to be a bit of a paradigm shift from the image
Yeah.
of the lawyer who helps bad people get off on technicalities. That's not how I see my job. That's not how you see your job. I
No.
mean, the way I see what we do is we are essentially the defenders of democratic constitutional rights. That's what we do. And we ask courts to uphold the democratic constitutional rights of accused persons so that we can all be free. And that's
Yeah.
how a constitutional democracy works. And I think certainly work needs to be done at the civic education level, to ensure that more people understand this. Because I mean, most people who know, those who are familiar with the criminal justice system, judges, other lawyers, even police, I think, understand the vital role that we play in ensuring that justice is actually served at the end of the
Yeah.
day.
Yeah. Well, I hope that that will change and that things will get better, and that we will see an improvement and we'll be able to keep more of our members in the bar. So, Nader, I want to thank you so much for taking the time to chat with me today. It was really very nice to see you and to talk to you after winning the award. Again, congratulations. Very happy for you. And well, I can't wait to see what else you're going to be doing to the profession, any new arguments that you're going to come up with, because it's very interesting to watch your arguments, especially on the Supreme Court and appellate level. So, thank you for your work and for your time today.
Thank you so much for having me. I really enjoyed our conversation.
Me as well. Thank you so much.